A Supreme Court vacation bench of Justices Vineet Saran and B.R. Kawai today ordered a YSR Congress leader from Andhra Pradesh and Member of Parliament Kanumuri Raghurama Krishnam Raju to be examined and admitted in Army Hospital Secunderabad. While doing so, the Supreme Court did not grant bail to the YSR Congress leader and has in fact slotted the case for next hearing on May 21st. Well, as a backdrop, YSR Congress leader had made certain provocative statements according to the state CID on social media and on news television, and on the basis of which sedition charges were slapped on the YSR Congress MP. He had moved the High Court for bail. However, the High Court had asked him to approach the Sessions Court for bail. And on the other hand, it had also formed a medical board to examine him. However, Raju persisted that he be examined in a neutral hospital or a private hospital since he did not trust the government hospitals to give a correct report. He had also alleged that while he was in police custody, he was brutally tortured by the state CID. Senior Advocate Mukul Rohatgi, appearing for the YSR Congress leader, submitted that it was an extraordinary case and it merits the Supreme Court's intervention as a grant of bail. He also suggested that they are open to him being admitted and diagnosed in a private hospital or the army hospital. Accordingly, the two-judge bench has now ordered for him to be examined and admitted in Secunderabad's Army Hospital. The court has, however, added that the period until which he stays in the Army Hospital will be considered as a judicial custody. The Telangana High Court was directed to nominate a judicial officer who will be with Raju during the examination. Raju's medical examination will be videographed and the medical reports have to be submitted to the court in a sealed cover. The top court has also ordered that Y category security provided under the orders of the Delhi High Court shall escort Kanumuri Raghurama Krishnam Raju only till the Army Hospital and need not be present at the time of medical examination. Well, in a related development, two Andhra-based news channels, that is TV5 News Channel and ABN Andhra Jyoti, have also moved the Supreme Court against the FIRs lodged by the ruling government in the state of Andhra Pradesh against these news channels for airing certain statements by the YSR Congress MP. The two channels have claimed that sedition charges cannot be claimed against the channels as it was violative of the fundamental right of speech and expression. ABN Andhra Jyoti has also claimed that ever since the YS Jagan Mohan Reddy government has come to power in the state of Andhra Pradesh, they have been targeted. Shortly after, Delhi police made close to 25 arrests in the national capital after posters were put out in the national capital critiquing Prime Minister Narendra Modi's COVID-19 vaccine policy. A petition has been filed in the Supreme Court by lawyer Pradeep Kumar Yadav seeking to quash all those FIRs filed by the Delhi police and also to stop the Delhi police from registering any further FIR in this regard. Yadav, in this regard, has relied on the Shreya Singhal judgment of the Supreme Court and also the recent observation and order made by the Supreme Court in the Sumomoto case of COVID-19 by Dr. Justice D.Y. Chandrachud, wherein the Supreme Court had noted that information by people on social media critiquing or sharing information on COVID-19 cannot be stopped. Yadav has submitted before the Supreme Court that such FIRs being registered by the Delhi police was violating the fundamental rights of the citizens and was also not in proportion to the crimes being charged as under the Indian Penal Code and the Disaster Management Act. The NGO Association for Democratic Reforms have moved the Supreme Court against the practice of executive appointing the Chief Election Commissioner and the election commissioners. ADR has essentially sought an independent collegium to appoint the members of the Election Commission of India. The petition contends that the practice of central government appointing Chief Election Commissioner and Election Commission members is violative of Articles 14 and 324 Clause 2 of the Indian Constitution. The bottom line of the petition by ADR is the executive making appointments to the Election Commission at its own whims and fancy is in a teeth of the very foundation of the Election Commission of India. Well, that's all from Supreme Court Today. Do stay tuned with Supreme Court Today tomorrow as well. And don't forget to like and share barandbench.com.